Okay, looks like we've got most of our attendees here. Thank you very much to everybody who's joining. We'll get started right now. So I'd like to say good afternoon to everybody. We're pleased to welcome you to this Bridge Legal and HR Solutions webinar. Today, we'll be talking about Bill 149, the Working for Workers For Act. Just to mention a bit about our company before we get started in the webinar, Bridge Legal and HR Solution is a unique consulting firm that brings employment law and human resources under one roof. So we provide not just employment law and human resources services, we also provide related services such as workplace investigations, workplace assessments, workplace restoration, and conflict resolution. And we're very pleased today to be discussing, as I mentioned, Bill 149, which is part of our employment law service offerings. We're just going to do a quick intro to the two of us representing today, myself and Michelle, and then we'll get into some housekeeping items, and then we'll go ahead and start with the content of this webinar. So without further ado, I'll ask Michelle to introduce herself.
Thank you, Yandre. So I'm Michelle Bird. I'm an investigator and trainer with Bridge Legal and HR Solutions. I'm a former lawyer, current therapist, and consultant. So I use both legal training and psychotherapy training to try and put the focus on the mental health of employees as well as the overall health of workplaces. And for Bridge Legal, I do investigations, training, workplace assessments, conflict resolution, all sorts of things.
Thanks, Michelle. And my name's Yandre. I'm an employment lawyer also here at Bridge Legal and HR Solutions. I focus on employment law, including contracts and litigation related to employment law. I also do human rights related cases and matters akin to that. I also do workplace policies and related items. Okay, so we're just going to do a bit of housekeeping for today's webinar.
Great. So the session is being recorded, as you know, and participants will receive a link to the recording as well as the presentation deck after the webinar. You'll notice that cameras and microphones have been muted just because we have a fairly large group, but we do want to hear your input and your questions. So please feel free to put any questions into the chat whenever they happen to come up for you. Our colleague Heather is going to be monitoring the chat, and we've set aside some time to answer as many questions as we can at the end. You can also use live captions for the webinar. Feel free to click the Show Captions button in your Zoom toolbar, and then you can follow along with the subtitles on. And just a quick disclaimer, the training materials are the property of Bridge Legal and HR Solutions. We do want you, of course, to enjoy them, but please don't copy, share, or otherwise distribute them. Very importantly, nothing in this presentation should be considered legal advice. We're providing a high-level general overview only, but we are very happy to help you with any specific legal inquiries you might have, so you can feel free to contact us at info@bridgelegalhr.ca. Along that same vein, please don't put any legal questions or personal information or business information into the chat because that is not a confidential forum.
Great, thank you, Michelle. So we'll chat a bit about what we're going to be talking about today, which is really a focus on Bill 149, the Working for Workers For Act. We're going to be talking about the requirements of Bill 149, including pay transparency, the use of AI, and the new prohibition on including Canadian experience in certain job advertisements. We're also going to be talking about other changes from Bill 149 related to acts outside of the Employment Standards Act, including the Workplace Safety and Insurance Act. And we'll be talking about some other upcoming legislation, which is related to Bill 149 in the sense that it's part of the Working for Workers series of legislation from the Ontario government. So as I mentioned, this is Working for Workers For Act, Bill 149. So there were previously three other acts starting in about 2021. And since then, there have been three more acts. So we're currently on Working for Workers 7 Act that's currently being considered at the legislature. And we'll be talking a little bit about that later once we're done with Bill 149. So just as a bit of background to Bill 149, it received royal assent on March 21st, 2024, so just over a year ago. And it does modify a few pieces of legislation, including the Employment Standards Act, which is the key part of our discussion here today. It also amends the Digital Platform Workers' Rights Act, the Fair Access to Regulated Professions and Compulsory Trades Act, as well as the Workplace Safety and Insurance Act, as I already mentioned. Now, some of the changes have already been implemented, and some of the changes are yet to come. So Michelle's just going to give us a brief overview of the key dates that you need to remember for Bill 149.
Yes, as we go through the information, it's just important to remember that there are sections of Bill 149 that are enforced and some parts that are not yet. So we have three of the key provisions that are in force. Trial periods under the ESA and wage deductions are in force as of March 21st, 2024. Sections pertaining to tips and vacation pay are in force as of June 21st of last year. And then we have several provisions pertaining to job posting rules that we're going to go over in detail, and those will be in force as of January 1st of next year. So before we get into the details of what the new sections around pay transparency look like, we're going to talk a little bit about the purpose behind increased pay transparency. At its core, the hope is that it's going to encourage organizations to adopt fair compensation practices and also help enhance workplace equality, not just on the individual employee level, but really on a broader systemic level. We always hope that employers are being fair in terms of how they determine compensation, but the fact is everybody can be susceptible to unconscious bias, and unfortunately, sometimes that unconscious bias can work against historically marginalized groups in particular when it comes to their workplace compensation. So the hope is that increased transparency can help prevent that. This is also a way to empower employees and to level the playing field when it comes to negotiations. The more information that employees have, the more likely they are potentially able to negotiate fairly. So really, this is a net gain for employees. There's also a hope that this will help improve employee-employer relations. A study in the Journal of Applied Psychology found that employees tend to have a fairly negative view when employers are not transparent when it comes to compensation, both during recruitment processes as well as when employees start with a company. So the hope is that increased transparency will help improve levels of employee trust in their employer. It's also important to remember that this is really a reflection of a trend that was already in place. Even as early as the beginning of 2024, approximately 50% of employers were already putting out fairly comprehensive compensation information in their job ads. So this is something that was being done proactively, just in recognition of the fact that it's something that can be very good for employees, something that can increase trust, and something that people do want.
Thanks, Michelle. And then we'll have a look at what the actual law requires. So, as I mentioned, this is part of the legislation that's not yet in effect, and the timeline is that this comes into effect on January 1st, 2026. So, around 6 months from now, a little less. And it only applies to employers with 25 or more employees. And what it basically requires is that if you are an employer with that many employees, you have to make sure that your job postings online or any public job posting, even if it's not online, most are online these days, provide compensation information, either the actual expected compensation, so $50,000 or whatever the case may be, or range of expected compensation. Now, when the act was first announced, there was no clarity in terms of what expected compensation or range of expected compensation needs to be inputted and whether there was a limit, and the thinking was, well, could I put 50,000 to 150,000 as the expected range of compensation and basically just leave a big gap there. Since then, this has been clarified through regulation, and the regulation does state that the range of compensation cannot exceed more than $50,000 per year. So it would be permissible to say 100,000 to 150,000. It would not be permissible to say that it's 100,000 to 160,000, for example. So there is some clarity on what the expected compensation range can be in any given job ad. There's also specific provision that further regulations may be made. So, as this kind of proceeds and the government sees how it's working out, there may be additional restrictions or additional requirements that come in. So you want to keep an eye out for that. And there's also an exemption found in the regulations, which states that This does not apply to jobs that pay more than 200,000 and have an expected compensation of more than $200,000. And this really reflects something that Michelle mentioned previously in terms of the background to this. Employees who can pull in 200,000 or more have a higher negotiating powers than employee who cannot pull in that much. And typically these are C-level or higher and they're specialized employees that you're talking about. So you don't necessarily need to show your hand in those negotiations as the employer. In any case, this is new in Ontario, but it's not new in Canada. There are a few other jurisdictions that have pay transparency requirements. They're different than the ones that we're talking about today, but British Columbia, Prince Edward Island, and Newfoundland have pay transparency requirements that if you're operating there, you should be aware of and you should look into. And for sure, we can assist you with that if you need. Just contact us at Bridge Legal. But you can expect that this is going to come to other parts of Canada as well. Quite often, Ontario and British Columbia lead the way in changes, and then other provinces follow. So expect if you're operating in Manitoba, Alberta, or other provinces that this may be something that you have to do in the future. So with that, and with knowing what the law requires, Michelle's just going to talk a little bit about what the positives and the supposed challenges are of this legislation.
Yeah, so there have been some concerns raised from the employer community, as is often the case whenever new legislation comes into effect. So we'll talk a bit about positives and challenges. Let's start with the challenges, and then we can end on a higher note. So one of the concerns raised was that increased pay transparency could cause conflict with existing employees who started at a lower range of pay. So we all know that the job market does shift, and it's possible that employers might have to up their compensation in order to attract a certain kind of talent. And if that is transparent, if that is put out there in the job ads, existing employees might see that new employees are getting paid more, and that could cause resentment for those employees. There's also concerns that have been raised that it might cause candidates to expect the highest end of the salary range from the start, so making it difficult for employers to negotiate. And obviously, there is extra work on the part of HR and possibly people leaders to develop defined compensation processes. So that can feel very difficult for people who might already have a lot on their plate. Those are all valid concerns. It's understandable why they have been raised, but that doesn't mean that pay transparency is not workable as a concept. It just means that employers might have to be prepared to have more nuanced conversations with both candidates and existing employees, and also might need to ensure that they have very clear metrics in place so that they can explain exactly why people fall along a certain spot in their compensation range. Employers who are raising concerns about this should also keep in mind that if they think that employees don't know what the compensation range is or what other people are being paid, that's probably not the case. We all know that employees do talk to each other, do share information about compensation. So it's quite possible for employees to sort this information out, even if it's not put into job ads, even if employers are not super transparent about it. Employees are also a lot more educated on these topics and have access to a lot more information than they ever did before. It's very common for employees to be able to look in various databases and figure out what the market dictates in terms of their own worth. So this is not information that employees don't have. It just depends on whether they have to look for it themselves or whether employers are proactively putting it out there. Turning to the positives, I think there are a lot. This is a reflection of what people want. It was shown that almost 85% of Canadians are very much in favor of increased transparency. So this is a positive move in that it's a reflection of what people want to see in the job market. It can also represent an improvement to workplace culture. We talked about that trust piece. So as employers are more transparent about things like compensation, it improves trust and improves the workplace culture. It provides additional clarity to employees, which can be a good thing because the more clarity there is about workplace compensation, the less need there is to speculate. We do see a lot of problems arising in workplaces where employees are relying on speculation and gossip to figure things out. The more transparent employers are, the less need there is for that. A big one is a decrease in the time that is wasted in interviews. I think anyone who has applied for jobs or who has been on the recruitment side knows that there are times when someone goes through one interview, maybe even multiple interviews, and then at the end of that process, it's realized that the expected compensation is not what they were hoping for, and they're not willing to join the organization. And that's a lot of wasted time on both the side of the employer and the employee. So having that information out there in posted job ads helps bring down that wasted time. It can also help promote employee retention. So the more that employers are clear not only about their salary bands, but about the metrics that go into deciding what someone is paid, the more employees are likely to see their salary as a reflection of their own efforts. So that really increases employee morale and also employee retention. And then finally, a big one is the idea that this could help improve social equality. So we talked a little bit about the idea that having increased transparency decreases unconscious bias. So that's part of it. And also studies have shown that part of the reason for the gender equality gap, and this is just part of it, not by any means the whole answer, but that part of that gender equality gap is due to the fact that women are less likely to negotiate for higher salaries, at least not as strongly as men do, generally speaking. So the more that there is transparent information about what the high end of a salary band is, the more likely women are to negotiate for that amount. So hopefully, the more this transparency takes place, the smaller that gender equality gap will get.
Thanks, Michelle. Next, we'll be chatting a little bit about the artificial intelligence obligations as well as the Canadian experience obligations. So these are two new rules that also come into effect at the same time as the pay transparency rule that Michelle just spoke about, that I spoke about a little bit earlier. These are in effect as of January 1st, 2026. And same as with the previous rules, they only apply to employers with 25 or more employees. So it's not applicable across the board. In essence, these rules are going to require employers who use AI to screen applicants, whether that screening is, to weed out applicants they may not want or to make even decisions on hiring or not hiring. That's now going to have to be disclosed in the actually publicly posted job ad, meaning that, you will going to need to have a line there that says we use AI for XYZ purposes when we are handling applicants to this position. You also are not permitted to require Canadian experience specifically. Now, just to be clear, this doesn't mean that you can't require experience at all. It just means that you can't require that experience be in Canada specifically in a posted job ad. There is no current regulation exempting any particular field or any particular profession, but there may be exemptions coming down the line if there's further regulations on this subject. I'm not sure if there will be, but we'll find out as time proceeds. I mentioned on our webinar, on a previous webinar, that maybe lawyers could be exempt from this, given that Canadian law experience might well be required. But again, we'll see. That's not currently in the exemption. So there may be more coming down the pipe, or there may not be more coming down the pipe. Just as a bit of an FYI, what AI is, there is actually a definition of AI in the regulations, which I do encourage you to read. It has to do with a machine-based system that generates outputs such as predictions, contents, recommendations, or decisions based on user input. So it is a little bit more than just a tick box, but it is if you are using AI in the background to screen applicants, or if the platform you are using uses AI to do so, you're going to have to disclose that. And if you don't know if the platform you're using uses that, you might want to find out. Now, another couple of changes, and as already mentioned by Michelle earlier, these are already in effect as of last year. They're related to tips, vacation rules, as well as trial periods. So tip sharing, now you need to have a policy posted in a conspicuous place. That is a lunchroom or another place where employees frequently gather or pass through. And you have to maintain a copy of that policy for 3 years after the policy is no longer in effect. This policy is related to tip sharing, particularly where the tip sharing is with the employer or the owner of the establishment. And just as a general precondition to being included in a tip pool as the owner or employer, you do have to perform the same or substantially same duties as the people who are generally in the tip pool. So, if your waiters are in the tip pool, you're going to have to be doing waiting work just as they do in order to qualify. So this doesn't create new obligations as far as participation in the pool does. It does create an obligation to have a policy, to post a policy and to keep records. If you change the policy, so if in 2025 the policy looks one way and 2026 the policy looks in another way, so you replace the 2025 policy, you're going to need to keep a copy of that 2025 policy for 3 years in case the Ministry of Labor comes in and asks you for your records. Another item is basically just a bit of a change to how vacation payouts work. So the default position is that vacation payouts are paid right before the employee takes vacation. So an employee accrues vacation, and then the pay period right before they go on vacation, they get that vacation paid out that they accrued. Now, we all know that not every workplace handles vacation pay this way. In some workplaces, the employees get their vacation paid on every paycheck. In other workplaces, the employees get their paid vacation, or get their vacation pay, I should say, on a date agreed between the employer and employee. I've seen all kinds of agreements. Some employers pay it once a year. Other employers pay it in the default way. So what you need now going forward is a written agreement of that. You can't just rely on a verbal agreement anymore. It used to be that you could just, the employee could just tell you, I want my vacation pay on January 31st, and then they're paid on January 31st. You're going to have to get that in writing going forward. And that's just a change that perhaps is expected there, just so the records are kept of when the vacation payout was requested. Now, just to be clear, if you already have that in your contract, and your contract states that you're paid vacation pay on each pay period, then you've already got that written agreement in place. The final item to mention here is the trial period change. So in essence, employees who are on trial periods are now included in the definition of employee. Now, my view is that this change in Bill 149 is not really a change, because trial period employees should have been paid as employees all along. They are doing work. But this is not a probationary period situation. This is about trial periods, which are often used in restaurants and similar businesses to basically test an employee before bringing him in as a full-on employee, let's say it that way. You're not going to be allowed to do those unpaid anymore. Not clear that you could before either, but clearly the government thought that there was too much of that going on for it to be left unsaid in the legislation. So there's much more clarity now on that. So in addition to the changes to the ESA, as I mentioned, there's changes to other pieces of legislation, one of which is the Workplace Safety and Insurance Act. And we'll have Michelle chat a bit about what that change looks like.
Yeah, so as Yonder mentioned, some of the changes that came in under Bill 149 were not actually changes. It was more so a clarification of what should have been happening anyway. The WISIA changes are actually changes. They're brand new, and there's two. One of which is a bit more understandable, and one of which is maybe a bit less understandable. So the first has to do with firefighters and fire investigators. Essentially, any firefighter or fire investigator who has at least 15 years of tenure and is subsequently diagnosed with primary site esophageal cancer will be presumptively entitled to benefits. So that means that they will not have to bring in proof that their cancer is due to their job. It's just recognized that there are chemicals in fires that can cause esophageal cancer, and they will get their benefits. So that is a very compassionate change that's coming in under the WISIA. The other change is super indexing, which we're not going to get into in too much detail, but it essentially just means that the lieutenant governor and council can bring in additional money for those on WSIB benefits to bring their benefits higher over and above the rate of inflation. So normally their benefits increase as inflation increases. This is a higher amount. We're not sure what the amount is or how they're going to determine it, but the change just gives the lieutenant governor and council the ability to do that. Really, all employers need to know is that this could result in higher WSIB premiums because premiums come from obviously employee benefits. If they are receiving additional benefits, that means that experience rating goes up for employers, and therefore benefit costs could go up depending on how this plays out.
Thanks, Michelle. A couple of other changes also stemming from Bill 149. These are the changes to the other piece of legislation I mentioned, the DPWRA and the FAR PACTA. That is the Digital Platform Workers' Rights Act and the Fair Access to Regulated Professions and Compulsory Trades Act. So the change to the Digital Platform Act, which is an act that applies to workers that are commonly known as gig workers. So, Uber drivers, DoorDash delivery people, those kinds of individuals. The new regulations will basically permit the minister to create regulations as to minimum wage requirements and how those are met. So basically calculating how a person is being paid and whether that payment matches what the minimum wage requirements are for these gig workers. So there's a lot in the regulations and details in there that I would encourage you to look at, in particular regarding to what happens when when the individual accepts a job, how long does that job last, how much are they paid across the time that job takes. So that is a change to the Digital Platform Act. The other changes are the Fair Access and Regulated Professions Act, which applies to professions such as lawyers, engineers, doctors. That legislation basically governs how people can attain accreditation in these fields. The new regulations are basically going to set out requirements for the regulators themselves, that is the Law Society of Ontario, the College of Physicians, and the other societies that deal with these kinds of regulations, on how they fairly and transparently actually allow individuals applying for those professions meet the requirements. So basically, they're going to have new requirements relating to transparency, objectivity, impartiality, and fairness, including provision of complete, accurate information regarding assessments of classifications, costs, timelines, criteria, and methods. And also a reduction of duplications. As anybody knows that's done any of these certifications, there's a lot of duplicate things that you're asked. And there's a hope that perhaps if we lower the barriers, we will be able to have people qualified much quicker than they used to be. In particular, as everybody knows, with doctors, this is, I think, a very good change. There's other bills as well coming up that we're going to talk about briefly today. One bill that Michelle's going to mention right now is Bill 190.
Thanks, Andre. So we've been talking about working for workers 4, and obviously we're not stopping there. We've got to go into working for workers 5, 6, and 7. There's a lot of these bills coming forward. So working for workers 5 received royal assent in October 2024, and there's a few really interesting provisions that are coming out of that. One that's not on the screen, but that it's important to keep in mind as well, is that there was a fairly significant increase to fines for individuals under the ESA. So it actually doubled from $50,000 to $100,000, and that was in effect as of October. There's also a prohibition on requiring medical notes for sick leave for employees who are covered under the ESA. That was also in effect as of October. And that what came into effect for a few very good reasons. So one is just to protect the privacy of employees. So in this case, we're not talking about a disability or a long-term leave. We're talking about a 1 day or a couple of day sick employee. So it's not the case where an employer might need to know detailed information about the employee's illness. So this was a recognition that employees' privacy should be protected where it can be protected and not require them to provide a sick note. It was also meant to decrease the burden on employees who might be experiencing an illness. So not requiring someone who might have a cold or a stomach flu, making them go to the doctor when they don't need medical treatment, just to get a note. And along the same lines, it's also meant to decrease the burden on our medical system, particularly after the height of the COVID-19 pandemic. So not requiring people to gather, to take away time that might be needed for other purposes in our medical system. It does allow for employers to ask for reasonable evidence in cases where employees are ill. It's not entirely clear what that means. It's been suggested that employers might require a signed declaration from employees, but again, it's not entirely clear what is meant by reasonable evidence. There's also a requirement that job postings indicate whether the posting pertains to a currently vacant position. This is also under the ESA and will be in force as of January 1, 2026. This was meant to address situations where employers are essentially testing the market to see, what's out there, is there interest in certain positions, but don't actually have a vacant position open. That can be a bit of a waste of time for job seekers. So now it's required that it's made clear in job ads whether there is a position vacant at the time. There were also amendments to the Occupational Health and Safety Act to include conduct occurring virtually in the definition of workplace harassment and sexual harassment. That's another one of those situations where really this should have been happening all along, especially after the COVID-19 pandemic, where so many people are working virtually. Obviously, people cannot be engaging in harassing behavior over Zoom meetings or Teams meetings or even email. So now it's expressly recognized that those behaviors, even when they occur virtually, can be considered workplace harassment or sexual harassment if they meet all the other criteria. And then finally, there's new regulations regarding washroom cleanliness, which is probably something we can all get on board with. So as of July, so a few days from now, it's going to be an actual requirement that employers ensure that washroom facilities are kept to a standard of cleanliness. And as of January 2026, there's also going to be additional requirements for posting cleaning schedules to ensure that that cleanliness is being kept up.
Thanks, Michelle. So that was Working for Workers 5 Act. There's also Working for Workers 6 Act, which is Bill 229. That one is from December 2024. There's several provisions in there. The key ones that interest us today are a new requirement, which just came into effect a few days ago, June 19th, 2025, which is a requirement that employees with at least 13 weeks of service are entitled to a unpaid leave of up to 27 weeks if they're unable to perform their duties due to a serious medical condition. So unlike the sick leave that we were talking about just a moment ago that Michelle mentioned, this is a more long-term illness where the employee cannot do their job because of the illness. And it's a leave of up to 27 weeks, as I mentioned. There's a big difference that in this case, you will be permitted to request, and in fact, the employee does need to obtain from a qualified medical practitioner a certificate that states that the employee is unable to work due to a serious medical condition, as well as the duration that the employee is unable to work due to that condition. So there's a little bit more certainty for employers there stemming from this leave in terms of knowledge that, okay, this employee is going to be out for 10 weeks or this employee is going to be out for 15 weeks, whatever the case may be. There's also increased fines under the Occupational Health and Safety Act. So the minimum fine of for subsequent offenses is going up to 200 to $500,000, excuse me, for any offenses, a subsequent offense that results in a death or serious injury in a 2-year period. This is meant to address basically employers that are reckless with respect to safety. So, if you're getting this many accidents at your work site or your workplace, that result in death or serious injury, you can expect that the Ministry of Labor is going to be looking more closely at your workplace and your practices, and they'll also fine you in greater amounts, as you can tell. Another bill is Bill 30, which is the Working for Workers 7 Act. So this bill was introduced on May 28th, 2025. This is not yet law. It's not yet been passed. It's currently undergoing review at the Parliament. Parliament's not sitting during the summer, so you can expect that there's going to be more action on this later in the year, but nothing for a few months. There's a few provisions in there that are kind of critical to look at. There's more than this, so I encourage everybody to look at the bill. But there's a new requirement for job posting platforms such as Indeed, such as LinkedIn, and other platforms that provide similar services to provide a fraud reporting mechanism for fraudulent job advertisement. So if you see that there's a job ad that sounds too good to be true, you should be able to now, going forward, make a complaint about fraud there. The fraud mechanism is required to direct the complaint to the operator of the job posting platform. So whether or not they take any action in the end is in their hands. There's a new job seeking leave. This only applies for employees who are terminated in the context of a mass termination, which is a termination of 50 or more employees within a short period of time. During a mass termination, there's kind of two options employers have. They can provide working notice or they can provide pay in lieu of notice. If you provide pay in lieu of notice, there's nothing here to be worried about. But if you provide working notice, you need to provide at least 3 days of unpaid leave for the employee to seek work during that notice period. This is just a recognition that, employees who are required to work during this period do face a bit of uncertainty. So this lets them have a little bit of time to look for work. There's also provisions for extended layoffs periods that are going to be in effect if this law is passed. The new layoff period can be of up to 52 weeks in any 78 consecutive week period of weeks, but unlike the other layoff periods, the 13-week and the 35-week layoff periods, for this one, you need agreement with the employee and agreement from or rather approval from the Director of Employment Standards, who is one of the administrators of the Employment Standards Act. So the Director of Employment Standards would need to sign off on such a layoff. So it's not going to be something that you can just give to the employee in a letter and expect it to work. So those are the items we're going to be talking about today. Now we've got some time, and I see that there's questions waiting in the log. So Heather, if you can please take us through some of the questions, we can start answering those.
Yes, perfect. Thank you, Michelle and Andre. So, first question is, excuse me, in regards to the pay transparency. Oh, I'm sorry.
Mhm.
Is that for base compensation only, or would it include bonus and commissions when it's for the over $200,000 earnings?
So there's maybe some nuance there, but I would imagine that it's going to include total compensation just because of the broad definition of what wages are under the Employment Standards Act. So my view is that it would include the expected compensation for that position, total compensation for that position.
Perfect. Thank you. Another question around pay transparency. In terms of less time wasted in interviews, is it still fair for employers or interviewers to ask what the candidate or interviewee's expected salary or salary expectations are?
Yeah, when it comes to the pay transparency, the obligation is just to put out there what the salary range is within those parameters that's outlined in the regulation to make sure that it's a salary band that makes sense and is not too wide. In terms of asking for expected compensation from the part of the employee, that's just kind of part of the negotiation process that would go back and forth, but that's not prohibited by the bill or anything like that.
Perfect. Thank you, Michelle. Vacation pay. So vacation pay is usually paid out while the person is away in this person's case. Are we now supposed to ensure they always request it that way or that they want it ahead of time, or can we continue as per practice?
Well, it sounds like that's the default position, which is pay, when the vacation commencing. So that's fine, and you don't need an agreement for that. If the employee does request it in a different way, then if you agree with that as the employer and you don't want to follow the default position, then you need to get that in writing. That's the only real change here. You need that agreement in writing.
Thank you. And from Amy, RE written agreements for vacation payouts. If there's no formal written agreement regarding vacation payouts, how should an employer proceed when the written policy is introduced? And then the second question, and the employees may not agree with its terms.
Oh, well, I'd say contact us. There's the number on the screen and our email address. But, in a more general sense, the default position doesn't require agreement. The default position being that, you pay it right before the vacation commences. It doesn't matter if the employee agrees with that or not. That's the Employment Standards Act obligation. If you want to change it to pay it in a different way, then you need a written agreement for that. And then you can discuss with the employee on whether they would agree to something else, but you would always have the backup position that the default position governs.
Perfect. Okay. Thank you. And one final question, which I believe we answered, but at what point can an employer ask for a sick note?
So I'll tell you that there's 3 unpaid sick days in the Employment Standards Act. So you can't ask for those 3. Once you hit day 4, you can. So you can ask after the third sick day in a year.
Perfect. Great. Thank you. As of right now, we have no other questions in the queue. If anyone has any questions, we do have another minute or two. Feel free to pop that in. Okay. I don't see anything else coming in. So otherwise, I think we're coming to an end. DeAndre, back to you.
Thanks. So thanks everybody for joining us. Oh, I see a couple of
I
them.
see a few more.
We might as well.
Yeah. So if you pay for the 3 sick days, you can ask for a note.
No, I will say you can't if they're the first three sick days, unless you're going to offer 3 additional unpaid sick days as well. So if you're offering 3 paid days and 3 unpaid sick days, you could. But if you're offering 3 paid sick days and you're still ticking off the ESA sick days as a result, you can't ask for a note.
Right. Perfect. Okay, I believe this person has quite a few questions, which is very understandable. I would suggest, if you have lots of questions around sick time, please reach out to info@bridgelegalhr.ca, and we are really happy to help support in answering those questions for you. We do have one additional follow-up here on vacation pay. Are agreements required if they are paid in the normal pay cycle, where the vacation pay comes after they take vacation?
Yeah, this is an interesting scenario because technically speaking, that's not in line what the Employment Standards Act requires, but it is a very, very common practice. I'd say contact us and chat with us about what to do in that scenario.
Perfect. Okay, great. I'm going to pass that off to you, Yandre, and Michelle to close off.
Great. Well, as I already thanked everybody, I'll thank everybody one more time. Thank you very much for joining us for this Bridge Legal and HR Solutions webinar. As I mentioned, we're a professional consulting firm that provides employment law and human resources support under one roof, as well as in related fields. So if you have any need of any support in those areas, please feel free to reach out at info@bridgelegalhr.ca. You can also call us 647-794-5442, and be more than happy to help you and your organizations with any questions you have. Thanks very much.
Wonderful.
Thank
Thank you.
you.
And upon leaving the webinar today, you will see a pop-up to complete a survey to give us some feedback, and we would love to hear from you. Otherwise, all of this information will be emailed to you in the coming hours. So stay tuned, and thank you for that.
Thank you.
Thanks.